Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, and thank you for stopping by. All right, guys, I have something for you tonight that I've never done before. I have an interview with the General Counsel of NSSF. This is the National Shooting Sports Foundation, the largest retail organization that sells firearms and the outdoors in the United States. This is the top guy talking to us around gun control in the United States, present and future. This is something that you are going to love, and please watch this whole interview. We dive into everything. Measure 114, we hit AR bans, we hit mag bans, we hit PLCAA. We talk about where this is going, and you guys are going to love this because he said some things in this interview which made me really smile and blew my mind. Now, let me know what you guys think of this style. If you want me to do more of these, I would love to do it if you guys are down. And if you are new, we would love to have you subscribe, join the fold. We need as many people as we can in the subscription list. We try to earn it every single day, twice a day, to pass the blessing on to the next generation. And thank you so much in advance for your consideration. Without further ado, let's dive into this interview with the SVP and General Counsel of NSSF. All right, my brothers and sisters, as I mentioned in the introduction, I have an absolute treat for you. I have a guest on today. This, as you see, my opposite on the screen is Larry Keane, SVP, Government and Public Affairs, and General Counsel for the NSSF. This is the guy who runs all the lawsuits, knows all the things for one of the largest shooting sports foundations in the entire nation. Larry, thank you so much for jumping on.
It's a pleasure to be with you. Thanks for having us.
Man, I've been looking forward to this conversation. As we mentioned, we are going to dive into the Oregon case. I'm sure other things are going to come out, but this is something that's so amazing. But before we dive into that, you actually have some history on something that we talk about all the time. You were actually involved in the passing of the Protection of Lawful Arms and Commerce Act, the one that prevents all the gun industry companies from being sued out of existence, didn't you?
Yeah, it's one of the highlights of my career is I helped to write and lobbied for passage on a bipartisan basis of the Protection of Lawful Commerce and Arms Act. In fact, a copy of it is hanging up over there, right behind me on the wall, signed by President Bush. It's really one of the highlights of my career, and it's really the single most important piece of legislation ever passed by Congress as far as the firearms industry is concerned.
Oh, I completely agree. I mean, that's one of the number one targets. They can't pass it legislatively. They're going to go through executive actions and executive bureaucracies. They can't do that. They're going to try to defund it through litigation and basically suing it into the Stone Age. And without that piece of legislation, we'd be in a very different place than we are now.
We hear the politicians, Biden, Hillary, others on the campaign trail, how they're going to repeal the gun manufacturer immunity bill, which it's not. It doesn't stop all lawsuits. Only junk, frivolous ones that really have no basis in American jurisprudence.
Right.
Trying to blame manufacturers for the criminal misuse of lawfully sold firearms. You don't sue, GM when someone misuses a car, like to drive into a crowd and mow down cadets at the LAPD Academy, for recent example. So, and we see the gun control groups constantly trying to find new and creative legal theories to try to circumvent and, pierce the law and, drive a big hole through it that you can drive a truck through. So They tried to do that. They tried to do that. And they frankly had some success in the case arising out of Newtown, the Soto case. We think the Connecticut Supreme Court decision was badly wrong. And so they, were always trying to chip away at it and undermine it. But I don't think it will be repealed by, Congress anytime soon, because it's bipartisan support and it's really just common sense.
Right. And it is just common sense. But first of all, thank you so much for that. That's not why we brought you. We're about to dive into the Oregon cases.
Happy to talk about the latest challenge that we're facing, the Oregon 114, which just barely passed, but we think is obviously unconstitutional. And that's why NSSF has filed a lawsuit along with, a gun group, some consumers, and one of our Oregon retail members to challenge it on Second Amendment grounds.
Yep. Well, let's get into it. Oregon. One of the things that we've been hitting on so hard on this channel across the gun industry is 114 is some of the most extreme gun control measures that were passed through a ballot initiatives. And now it's running into trouble in the courts. I mean, I think we were talking offline, and there's so far 5 different lawsuits. And just to bring everyone up to speed, currently the GOA lawsuit around the magazine bans has an injunction, which is going until the 13th of this month. But that's not even all the trouble it's in. I mean, NSSF has their own, don't they?
Yeah. So you mentioned there are 4 cases in federal court. NSSF is a plaintiff in one of those cases, along with the Oregon Shooting Sports Association and a retailer that's a member of ours, and a number of gun owners, some of whom are former Oregon legislators. And then there's also the case in state court, which actually challenges not just the magazine ban, but it also challenges the permit to purchase, as I understand it. So the state court judge granted what's called a TRO, temporary restraining order, until December 13th. The state appealed to the Oregon Supreme Court to have that overturned. And frankly, surprisingly, and encouragingly, the Oregon Supreme Court denied that appeal and let the order stay in place. On the 13th, the state court will have a hearing on the motion for a preliminary injunction. And that case is based on a challenge based on the Oregon state constitution, which has a Second Amendment equivalent provision in it. And then there's the 4 cases in federal court that have been filed. In the OFF case, the court denied the TRO, but based on the state's representations, acknowledging at the last minute that they in fact cannot implement the permit to purchase scheme, has been stayed until January 6th. But we expect that, but then denied the TRO as to the permit to purchase and magazine restriction. There are several, the other cases now also have motions pending, challenging on the Second Amendment grounds, due process grounds, and the taking clause. So scheduling orders are being worked out. I expect to see, based on those discussions, that the stay on the permit to purchase will be extended to early February, and we'll see if it gets extended beyond that. And so on Sunday, this past Sunday, the state sent a letter to the court essentially saying, we know we can't implement this on the 8th, so it's okay with us if you stipulate to put it off for a while. And the reality is that they absolutely cannot implement it at this time. But even if they could, it doesn't solve the constitutional problems. It's still, even if it could be implemented, still violates the Second Amendment. And of course, the magazine restriction is I think, a transparent violation of the Second Amendment, particularly in light of the post-Bruen world. The Supreme Court set forth the proper test that was really laid out in Heller, and Bruen said, this is the test. We said what we meant in Heller. And unfortunately, the appellate courts, as Justice Thomas explained in Bruen, were not faithfully applying the test, and had created a test that wasn't in Heller. And actually it had been expressly rejected by Heller, this, interest weighing so the government for public safety versus your individual rights. That's not the test. That, sort of scrutiny test is not the test. So we're disappointed by the federal court judge's ruling denying the TRO in the OFF case, because we believe the court really did not faithfully apply the test laid out in Heller and reemphasized in Bruen, and wrongly placed the burden on the plaintiffs to prove a need for self-defense. And that is clearly not the test. The burden is on the government to prove that the restriction on bearable arms is consistent with our national tradition and heritage on firearms restrictions. And we don't believe they can make that showing at all. So,
right. And You just hit on so many things. I almost
Right.
don't even know where to go. I mean, there's so much to this fight that we're in, and it's
Yeah.
something that we talk on this channel consistently about. This is a long-term fight, but we have the win behind us. Like we have the rulings, we have Heller, we have Bruin, we have all of these different support structures with the Constitution itself, the Second Amendment, all of these incredible things that are going against what they're trying to do. And so, like I said, you hit so many things there. I'm going to follow up on a couple.
Sure.
First one, I mean, the magazine restriction that was at question here, this actually has ramifications beyond Oregon. I mean, like you just had Washington State come out last year and pass a magazine ban. You've got Colorado with a magazine ban. There's magazine bans in a lot of states. What do you think the implications would be here?
Well, there are, I think now, if you include Oregon, I think it's 9 or 8. So if we prevail and the court strikes down the magazine restriction on Second Amendment grounds, and it goes up to let's say it goes up to the Ninth Circuit, and the Ninth Circuit affirms a ruling, striking it down, then that applies in all of the states covered by the Ninth Circuit. So Washington, California, et cetera. So it does have implications beyond Oregon. Conversely, if we do not prevail and the Ninth Circuit upholds and says, no, it's not, it doesn't violate the Second Amendment, that has implications as well, just in the other direction. But I think it seems to me that while it may take 3 years or so, I think many of these cases that are now being litigated post Bruin, the Fourth Circuit, several cases in California, for example, and now this case, Washington, et cetera. I think we're going to see the Supreme Court take up bans on modern sporting rifles or bans on magazine capacity sometime in the next 3, maybe 5 years at the outside. So
okay,
so I think it's hard for the court not to flesh out and rule on some of these things. These things that were not directly decided by the Bruin decision, which
right,
was about the right to carry outside your home, and versus what firearms are covered or not covered by the Second Amendment.
Well, and so, man, this is great. I'm loving the direction this is going. So, I mean, stack that a little bit further. Like, I mean, you mentioned to it from the Heller decision, the right to establish, basically have your own firearm, which is mind-boggling that even had to be said. Then you've got Bruin, which says, oh, well, not only can you not only have it, now you can actually carry it and defend yourself. So it's stacking in that right decision or in the right direction. So that's actually something that we hear a lot from the viewers on this channel in the comments. These AR bans are unconstitutional because they would be considered common use. I mean, like if you're looking at it and doing a test, this would be a common use item, just like a magazine would be, all these different items. What's your take on that? Do you think that has a real good holding?
I think you're exactly right. Unquestionably, modern sporting rifles are commonly owned and they're commonly used for lawful purposes, including self-defense. There are by now 25 million plus modern sporting rifles in civilian possession in the United States. And to kind of put that in perspective, in a case out of Boston or Massachusetts, in a First Circuit case, the Supreme Court 9-0 said that stun guns, at the time there were estimates that there were somewhere between 200,000 and 300,000, of them in civilian possession. The Supreme Court said those were commonly owned, commonly used for self-defense, and were protected by the Second Amendment. People say, that Bruin was the first Second Amendment case since Heller. That's not entirely true. It's the first gun case, but this case by the Supreme Court said 200 plus thousand stun guns were in common use. Well, in 25 million rifles, by the way, the most popular rifle being sold in the United States today,
hands
for
down,
lawful purposes that are rarely used in crimes or in homicides, very small number. I mean, often tragic, high profile, but still is a relative number. They are clearly bearable arms that are commonly owned and used for lawful purposes. So I think very clearly, and so once that's established, then the burden under Heller, and as emphasized by Bruin, is the government's burden to prove that limiting ownership of those bearable arms that are covered by the Second Amendment is consistent with our national heritage and traditions for gun restrictions that existed at the time of our founding, the time the Constitution was adopted. And clearly, that's not the case. There were no restrictions on what firearms you could own based on what type they were. And then, so the other side tries to argue, first, one of the arguments they make is, well, it has to be commonly used. And we hear this even in the magazine cases. They're not commonly used because, you rarely ever fire more than 10 rounds. Well, that's not the case. It's not commonly fired, right? It's commonly owned and commonly used for lawful purposes. You purchase the firearm for the purpose of using it for self-defense or hunting or target shooting, right? And so the test isn't how many times did you actually pull the trigger. That's like saying, you don't own golf clubs for golfing because you rarely golf.
Right. Right. Exactly.
So that's not the test. Then we see this all the time now, particularly post Bruin. The court said firearms that are dangerous and unusual could fall outside of the scope of the Second Amendment. Now what we see the other side saying in court is dangerous, and then they literally take out and insert in brackets or, which is just purposefully misleading to the court, because that's not what the court said in Heller.
100%. And if memory serves correctly, they actually, in the Oregon cases, they actually put that in their argument in one of the cases that said, well, the average is 2.2 firings.
It's not commonly used. Yes.
Right. They actually put that in what we're discussing. That's crazy.
Yes. And so when you think about it, right, like, isn't it a good thing? Right? Like, so, Heller was about a categorical ban in DC on handguns. And in Heller, the court, Scalia said and wrote about, look, more crimes by far, most crimes, gun crimes are committed with handguns, not rifles, right? But they're talking about handguns. But that's not an argument for banning handguns because it's also the weapon of choice chosen by law-abiding gun owners for the purpose of self-defense. And clearly, the overwhelming majority, probably 99% of all the handguns ever sold or owned are never fired in self-defense.
Oh, absolutely.
Under that argument, that wouldn't matter. You could ban them. So and so the same applies in the case of rifles, for example. That some are misused is not an argument under the teachings in Heller and Donald and Bruin. It's not an argument to ban them. I could reduce slander and defamation if I banned computers.
Right.
But no one would say, well, banning computers is okay, doesn't violate the First Amendment because slander is not protected by the First Amendment. And you could reduce slander. Well, that's that interest bearing, right? Like that's not the test. Clearly.
Well, something else, and they're kind of just wrapping up the conversation on that. Something else that they're doing that I found to me is just egregious. Like I cannot believe that they're not getting called out on it. Is when they're looking and they're searching. I mean, they are pulling up every rock possible to find a way for historical text and tradition to satisfy the Bruin for all of their infringements. There are two cases that they pulled in, and they said on both cases, most to do with ghost guns, it was perfectly fine for the government to discriminate against gun owners because in the 1600s, they went after Native Americans and Catholics. It's like, no, we've discriminated before. It's okay. It is mind-boggling.
Really incredible, right? Like, and they also have cited to like gun control laws passed at the time of the 14th Amendment, right? In Reconstruction, which were laws designed to disarm recently freed African Americans in the South. So, I mean, it's mind-boggling.
Yeah.
And as you know, the origins of gun control, that's the
100%.
origins of gun control, was racism, right?
Yes.
So, I mean, breathtaking. And, you know, I'm Catholic. That they would then make that argument is infuriating to me personally. It's outrageous.
I don't know. I mean, so like just from a standpoint of strategy, yes, it's outrageous. Yes, it's insane. But for me, it's like, are they cutting off their nose to spite their face here in the future? I mean, like, your argument is based on that?
Because they don't have any that's all they have, right?
Right.
They don't have any argument. They can't point to any actual tradition. And as the court said in Bruin, you know, one, you know, ordinance somewhere is not a tradition. It's, you know, not a national heritage, right? You have to look at the, you know, nationally, and it just wasn't these kinds of laws. They just weren't. I mean, and of course, as we know, these gun control laws don't actually make us safer. They just
not at all.
Infringe upon the ability of law-abiding Americans to own firearms for lawful purposes, including self-protection. It's just that simple.
You know, it's so funny because when we originally set this conversation up, we were diving into the Oregon conversation. Man, this got so much.
5 minutes.
No, it's okay. It's okay. I genuinely really enjoyed that. That's incredible. So kind of, just so I can be honest with my advertisement for my audience, from the Oregon, just like the Oregon stuff that we're talking about, you said 2-3 years you think it's going to work through the system.
You know, it just takes a long time.
Right. It takes a long time.
You get 3, it could be 5, but by the time you know, it gets there.
So what do you think, kind of in wrapping it up, what do you think the most powerful approach is, and which one do you think will be the most effective in all of the Oregon cases we're seeing? What do you think?
Well, I think we'll see what happens in the state court case. I wasn't even aware that case had been filed until all of a sudden the TRO was issued.
Right.
So, you know, that's an interesting case. I think, you know, all the federal cases are essentially going to be, you know, as a practical matter, consolidated and handled all in one by the federal court, which, you know, from the court's perspective makes sense. From the parties, you know, perspective, it makes sense, you know, judicial economy. So they were all kind of going to get wrapped up into one, if not formally consolidated. Her orders will apply to all. And so, you know, she will decide the preliminary injunction. Based on our TRO order, you know, we have concerns, but we're certainly going to try to explain to the court why we think her TRO was incorrect, and that she improperly shifted the burden to the plaintiffs in the case, and relieved the state of its obligation. You know, even in the context of a preliminary injunction or a TRO, you know, when you're talking about a constitutional right, the burden's on the government. You know, normally in that context, it's on the plaintiff to establish. But if you establish these are commonly owned, they are bearable arms, you know, then it's the burden is on the state. But whoever loses the preliminary injunction in federal court will undoubtedly appeal to the Ninth Circuit.
Right.
So the case will be in the Ninth Circuit, you know, probably later this year. When the Ninth Circuit gets to it and decides it, that could take, you know, 18 months or something like that. I'm not sure what the Ninth Circuit's, you know, kind of running, like how long it takes, but it'll take a while. And then, you know, then it could go from there to the Supreme Court, at least, you know, an application of what's called a cert petition, and we'll see what the court does. If it comes back to the district court from the Ninth Circuit, you know, then it would go through discovery, more intense discovery, and then a trial, you know, summary judgment motion. So it'll take a while.
Gotcha.
The case, you know, could be around for a while, but you know, and the same goes for many of the other cases that are now, you know, that were at the Supreme Court with cert petitions that were granted and then sent right back to the circuit courts. And then the circuit courts have largely sent them back to the district courts to decide anew based on the Bruin decision. So all of those cases will eventually work their way back up to the appellate courts, and we'll see what happens. But hopefully the appellate courts and the district courts now will apply the Heller test as emphasized and made more clear if it needed to be in the Bruin decision. It is not the interest weighing, tiered scrutiny that had been adopted really based on Justice Breyer's dissent in the Heller decision, which was expressly rejected by the majority in Heller, saying that ain't the test. Well, they didn't. And as Justice Thomas wrote, and many dissents in cert petitions prior to Bruin, several justices wrote about how this is not the right test. Supreme Court is being treated like a second-class right. So I think, the decision in Bruin hopefully will be faithfully applied by the appellate courts, so that, we can see these laws stricken down. And unlike what the other side tries to claim, it's not going to be the end of the world. It's not going to be blood in the streets. I think we'll be safer as a society if people can protect themselves.
100%. And that is an excellent last statement of this interview. Mr. Larry Keene, SVP Government and SVP Government and Public Affairs and General Counsel of NSSF. I appreciate you so much, not only for what you did with the PLCAA, but also spending time with us today. That was so much fun. And I hope you guys come back on soon.
Anytime. It's great to be with you. Thanks.
Thank you, Larry.